Good afternoon and welcome to all the participants. It seems that there are not so many people today, and one of the reasons is that, as I tried to explain, our students are now fighting with their preparation for exams, and maybe this is one of the reasons why I don't see many faces around us, but what is important is also the quality of the attendees. So, and as far as this is concerned, I thank you very much for being here, and I welcome back Professor de Vries from the European Institute of Utrecht University, one of our most esteemed partner in research and teaching programs. Among which the transnational law program has been and is one of the most successful. We had very good figures as regards the participation of our students in the program, also quite recently, and we are quite happy with it. And it was launched some years ago together with Utrecht and University, and I have to thank here again Roberto Tognatti, who was our dean at that time, a great promoter of international relations, successful international relations. So thank you, Roberto. I wish, of course, to welcome and thank also our colleagues who come from Antwerp, Barcelona, Copenhagen, and Oxford. Their presence here shows that there is a wide participation as far as international partner is concerned in this important project, whose Trento unit is led by Elena Ioriatti, to whom I am grateful. Just a few words on the topic chosen for today's workshop. Barriers to the exercise of EU citizenship's rights, factual and legal analysis. It is meaningful that here we will discuss today the issue of barriers to the exercise of European Union citizenship's rights, I guess with the aim of overcoming those barriers, while outside of this whole many people have a harsh debate on the issue of building or rebuilding barriers and walls among states. These states and people, as you know very well, just a few years ago were celebrating the collapse of those barriers, walls, curtains. This few observation refers to today's meeting, but also in general to the process of integration of the European Union. It is clear that, as it happens quite often with any process, there are ups and downs during the path that has been chosen. But at the same time, what really matters is the fact that at the end of each phase of this process, there should be a higher level of protection. And this is very true for fundamental rights, leaving aside the issue, the specific issue of citizenship's rights. Your research project and today's seminar is surely aimed, as I said before, to single out and overcome all the barriers to the rights of the citizens within the European Union and within each and every European Union member states. It is for this reason that I wish you all the best in your future endeavors. Thank you very much.
Thank you very much to our Dean. thank you for a colleague being present and to the student. Just a few words. I would like to thank you all for being here, attending the Trento seminar of the project bEUcitizen. And particularly, I'm grateful to our Dean, Professor Nesi, for hosting the seminar, for his sincere participation and words, and to Professor Sybe de Vries, who nowadays is the General Coordinator of bEUcitizen Consortium, but who in 2012 had the brilliant idea of mapping and studying the shortcomings which prevent the exercise of the right of the European citizen, and submitted to the EU Commission within the 7th Framework Programme. And the result nowadays is a consortium of 26 universities and already 3 years of research activities. Unitn is the Italian partner in charge of the research in the field of law, and particularly we are coordinating together with Professor de Vries Work Package 5. I'm saying this for the students. That is the topic is on economic right, and we are also collaborating in Work Package 7 on civil right. And particularly, WP5 aim is to study from the perspective of EU citizenship both the problem that citizens and third country nationals face in gaining access to the economic rights, which are the core of the European Union. And against this background, we are mapping and identifying different categories of citizenship, specific substantive economic rights, and the barriers they face. For example, citizens' right to manage and protect the intellectual property and barriers to this right. And we are also dealing with linguistic diversity. Linguistic diversity is the symbol of the cultural richness of Europe, but unfortunately, it also turn to barriers, and one of the most common example is that language differences may be a barrier to the exchange of information. And on the other side, the drafting technique of the European Legal Act, mostly due to multilingualism, may create misapplication and misinterpretation of the citizen's rights in the different member states. So, Unitn team, so Flavio Guella, Paolo Guarda, Elisabetta Pulic, and myself, was created in order to respond to this research exigency by putting together different expertise. And after some years of research, we became aware of the necessity of discussing and analyzing one of the key issues of the project, that is the concept of barrier. So we decided that the best way to do that was a seminar internal to the project, in which researchers in the different areas of the law who had already mapped and studied the different examples of barrier could sit together with some leading experts, Professor Sybe de Vries and Professor Martin Seilb-Kazirer, to discuss this very important key notion of our project. And I also asked Luisa Antonioli to conclude the seminar. She is the director of the School of International Studies, and so she has a well-established expertise in research, not only in the field of law, but in the area of social studies too. So I thank you very much for being here, and I give the floor to our first keynote speaker, Professor Sybe de Vries of the European Institute Utrecht. Professor de Vries is a full professor holding the Jean Monnet Chair in Utrecht. He has published many books and articles on European law and on internal market. He has been also our guest lecturer in January within the course of a comparative legal system, and of course he is our general coordinator. So thank you very much. I give you the floor.
Thank you very much, Elena. Is it on? It is on. Thank you very much, Elena. Thank you very much, Professor Nesi, as well, for inviting me here. Again, I always love to come to Trento, and I have a very good memories of my lecture in January with the students. which was actually a lecture more related maybe, or closely related to my own research, and that concerns the EU internal market law, but then specifically in relation to fundamental rights, because that is a relatively new development within the context of European Union law, that the EU is now, especially since 2009, dealing with fundamental rights as well, although history goes back a longer time than that. But I'm not going to talk specifically about that. No, I'm going to focus on the topic of today, and that's the barriers, and I will just start my PowerPoint. It should be now, I have to see. Sorry, I will take that away, and here I am, I think. Yeah. See how good my Italian is? Well, it's perfect, isn't it? So that's one barrier less, I would say. I can handle the computer in Italian. And actually, it just, words, or what Professor Nesi said about we should strive for a higher level of protection of fundamental rights, for example. That is certainly one of the concerns that we are dealing with in our project as well, our research. Specifically, the research is working in work package number 7, and that's another thing that we have to learn also to work with terminology, which is typically Brussels terminology, because the word work package was completely new to me. And still, I have to sometimes explain that to my colleagues, what they are talking about, work package, and if you translate it into Dutch, it's even funnier. So I think that it is something which we cannot really visualize what it means, but it's simply kind of a sub-research within the overall research project, or sub-research project. And what I will do is I will actually go through our project and then particularly focus on shortcomings, problems and barriers, because that's the topic of today, but to try to do that from the perspective of kind of coordination, me as the coordinator, so dealing with the various actually topics that we are dealing with in our project. And, oh, I'm going too fast now. Well, first of all, Elena already mentioned that we are in a consortium of 26 universities, so that is quite an enormous consortium, I have to say. I don't think there are many other consortia having so many partners.
Almost as the European Union.
It's almost that we try to approach that, but unfortunately we missed 2 partners, so we're still maybe looking for them for the last year. But no, so it's really enormous. It's a vast consortium. And what is now the background of our project? Why did we start this project? And that was in response to a call by the European Commission, wherein the European Commission identified actually a number of problems, indeed the shortcomings that European citizens face in exercising their rights. And so the Commission actually sought, you could say, help in trying to identify these shortcomings, these barriers, but also try to come up with solutions, how to overcome these barriers. What can we do about it? But of course there are lots of questions which are sort of underlying these questions that the Commission posed to us and to others. And we responded then with this project, which is called bEUcitizen, Barriers Towards European Citizenship. And we, in our approach, departed from a heterogeneous concept of citizenship. And maybe that's also important because the law was mentioned as well by Elena, but in the end also other disciplines. We have a multidisciplinary approach, or even sometimes try to be interdisciplinary, which is a challenge, I have to say. So we, especially because citizenship, we feel that citizenship, or that's our starting point, developed between rules and practices. It's not merely or only a legal concept. It's much more than that. We needed this multidisciplinary approach. So within this consortium of 26 universities, there are historians, there are political scientists, there are social scientists, there are lawyers, economists, those working in the field of governance, maybe related to political science, philosophers. They're all working together in order to try to find answers to the research questions that we posed in our project. So a multidisciplinary, interdisciplinary approach. Now, in order to see whether and how barriers can be overcome, as well as, because that's our primary focus, we also would like to see what kind of concept of citizenship, or what kind of concepts of citizenship, or rather what kind of narratives related to citizenship could we develop and could also be of help for the European Union in the future to oops, now I'm in the limelight, to overcome these barriers once again. So how could we further develop this concept of European citizenship? Now, we were together at the beginning, but then maybe I try to help you visualize a bit our project. Then you could say that the researchers as scouts were sent out to explore the uncharted waters of European citizenship. And what did we find out, or what have we found out so far? First of all, the scouts were searching for the various pathways leading to European citizenship. And what do I mean with that? The historical perspective in our research. The historians, they have been looking particularly at the concept of citizenship from before, you could say, the birth of the nation state. So looking back to citizenship models of the Middle Ages, especially when the guilds in the cities had strong positions, were relatively strong, and citizenship was more locally organized. Could that be of any help, or the findings of their research of any help also to develop further this kind of idea and reality of European citizenship? That was kind of their main question. They are seeking, or is still their main question they are seeking to answer. What appears from their research so far is that pre-modern citizenship was relatively open to mobile newcomers. And pre-modern social and economic rights were reasonably accessible. So pre-modern vis-à-vis more modern citizenship, so that is from 100, 200 years ago, say after the French Revolution. So you could, or they argue, that pre-modern citizenship is more inclusive than national citizenship had been for a long time. And that means that local or regional forms of citizenship or citizenship models could provide a viable alternative to national citizenship. And they also stress the fact, the historians, that we have to realize that national citizenship was actually, or national citizenship communities, that they were the result of large, great efforts, especially also in education. Look, for example, to France, but perhaps that goes also true for Italy. Now then, looking from a comparative perspective to citizenship, is what we have found out so far is that the political autonomy and territorial protection of cultural interest of citizenship, or of citizens, may enhance integration. And that the possibility to preserve national or local identities may benefit integration. There we look at other federal states like Switzerland or Canada, which maybe could constitute models that could be interesting for the EU as well, to look how actually did citizenship develop within the context of these types of confederal states and states, for example, with multiple identities. Think about Turkey or Israel. Well, Turkey is maybe an example that I'm not going to dare to go into nowadays. So what they have concluded so far, I mean, research is still ongoing, I should say that, maybe repeat that several times, is that the Swiss model seems to be most apt. And that the preservance of these local identities and regional identities might benefit integration, but at the same time we need something as well, and that is a common approach perhaps to welfare or to securization of these local or national rights of these communities. So there should be some kind of common approach as well, common approach perhaps by the EU institutions. And they have also concluded that sometimes it's to be favored to prioritize commuting over mobility. I think that's also an interesting finding, especially if we later on turn to the presentation of Martin to see what he says about mobility and social rights and welfare systems. So maybe I should add to this as well, which is not on the slide, that if we look, for example, to Canada, it appears that a more plural, flexible system of citizenship can be combined, or can easily combine, I should say, individual and collective rights of citizens. So there, for example, the states within Canada, or the communities within Canada, have also powers to set up their own human rights or fundamental rights document, and they have also been adopted. So there's some kind of competing with that document with the federal protection of fundamental rights. That might be interesting if we look at the EU, how that works. Now, these scouts then, they were sent out to look into the various pathways of European citizens. But we have also scouts looking into the rights and the barriers, more specifically, of European citizens. And what have they found out? And we turn to the economic, social, civil, and political rights of European citizens. And they are being examined, as Elena already said, in Work Package 5, for example, when it comes to economic rights and social rights in Work Package 6, civil rights in Work Package 7, and the political rights in Work Package 8. Now, just an example, because now we have more and more examples actually, so we can look at that later on during this discussion perhaps, of what we found out in these areas, with respect to these rights. That we see that still the recognition of diplomas might be problematic, that there's even a question of non-recognition of diplomas, although we have a quite solid EU legal framework on that issue. And Elena already mentioned the linguistic differences, and I think we're going to dig into that later on, which constitute barriers to economic rights. Well, maybe the EU could take action to solve this, or maybe the EU could, for example, when it comes to linguistic barriers, a suggestion was made by the group of Elena to come up with a more better managed system when it comes to linguistic problems. Once again, we depart from this heterogeneous concept of citizenship, not seeking to replace it by some kind of homogeneous idea with 1 or 2 or 3 dominant languages. It's not our starting point. When it comes to social rights, we see that there are differences between social rights and welfare regimes in member states. I'm not going and not daring to say much about this because that will be Martin who will talk about that more. Then, when it comes to the civil rights of citizens, we see that there is a variety, and this actually goes true for economic rights to some extent as well, and an overlap of different legal regimes for civil rights. Of course, we have now, since 2009, the binding EU Charter of Fundamental Rights, sort of competing with the national constitutions, which is not a very big deal in the Netherlands, but I assume a much bigger deal here in Italy, and in Germany for that matter, and competing with the European Convention on the Protection of Human Rights. So we see different legal regimes. Do these different overlapping legal regimes enhance the civil rights of European citizens? Sometimes yes, but sometimes maybe not. Sometimes they may also be used in order to lower the standard of protection of fundamental rights. And then, of course, we have problems with the enforcement of fundamental rights and enforcing the rule of law in a number of member states now in the EU, just to mention Hungary and Poland, where where we have some problematic situation in that regard. So how could you overcome that? These are problems, and they might also lead to barriers for EU citizens to exercise their rights in these particular countries. Training of professionals could be something for the European Union to take up, raising awareness, monitoring EU fundamental rights violations, which is already, of course, happening. Now then, when it comes to political rights, I just mentioned a couple of examples because I think it is going to be too lengthy if I dig into everything, but I guess that there might be some questions and that we come back to that during the discussion. Then, when it comes to political rights, we see that some actually citizens are outside or seem to be outside the political system. Now, actually, this is not a European Union problem on its own, but it's also and definitely a national problem when it comes to legitimacy of the national political system as well as the EU system. So how could these kind of problems resulting in barriers for citizens, and if we then particularly look at European citizens, how could these be overcome? Those not exercising their political rights, which they do have. Is different way of registration of voters an idea? Online voting systems? Is increasing the power of the European Parliament a good idea or not? I was actually 2 weeks ago in Brussels, and then with a meeting, or at a meeting with Frans Timmermans, who is the Vice President now of the European Commission and responsible for, amongst others, better regulation and fundamental rights. And then when someone asked, well, shouldn't we now increase the powers of the European Parliament, he thought that was an old-fashioned idea. So we should definitely not do that. So maybe we should look into other alternatives. It was interesting to hear. Another alternative is, for example, the European Citizenship Initiative, the ECI, which has, according to a report published within the context of our project, the potential, at least the potential, to increase legitimacy of the EU. Now, what we see here when we look at these various rights that EU citizens have, and we now more and more after 3 years of research can see what are barriers to the exercise of these rights, is that the barriers are multiple. They are legal, and they sometimes relate to the fact, or definitely relate to the fact, that even within a single category of rights, within a single category of economic rights, for example, these rights compete with each other. Because which economic right might take precedence over another economic right? If we talk about intellectual property rights, for example, vis-à-vis consumer rights. Consumer rights we have also identified as economic rights. Or the right of one individual might, the exercise of that right, set constraints to the exercise of the right of another individual. And what about protecting collective economic rights vis-à-vis individual economic rights? So already it's inherent in this category of rights that there are kind of rivalries. But there are, of course, also rivalries between different categories of rights, which eventually may be or constitute barriers to the exercise of these rights. Well, a well-known example is the data protection or protection of privacy vis-à-vis, for example, consumers' rights to purchase goods and services online. One of the ideas already since a long time from the European Commission when it comes to economic rights is to increase the potential of the digital single market. That is certainly an important tool to stimulate the cross-border purchase of goods and services, so this wholly fits in the idea of the single market. But we see there, now we are about to conclude our report on that, is that apart from the fact that there's still lots of mistrust of consumers, that consumers, irrespective of the fact that they are well informed, are not always making the right decisions, and that's also kind of paradigm of consumers, the well-informed consumer, which is a typically EU concept of consumer, that does not always correspond to the reality. And for example, behavior economics now looks into that very much, like, is a consumer well a rational human being making informed choices and informed decisions? We can make these informed choices. But that's still sort of underlying the idea of the digital single market. And what about then their privacy? How is that being protected? So here we see a clash between rights, which may constitute a barrier for the consumers to indeed engage in cross-border purchase of goods and services. And of course there are other barriers. Now we also see, when we look, for example, at civil rights of citizens, one of the main civil rights that we looked into of citizens is the right to move and reside, the right to move to another member state and to reside in another member state, the core citizenship right. The EU has focused very much on mobility of EU citizens. And how does this relate to the sedentary citizen, the citizen who is staying at home, or the staying at home citizen? Also here we see that rights might clash. For example, mobility rights might clash with public security rights. Might be so that the state wishes to expel a citizen, thereby, of course, making his right to reside in that other member state impossible for or on grounds of public security. Well, there are good reasons for a state to do so, but here we see again a clash between rights resulting in a barrier for the citizen to exercise these rights. Now, next to that, these legal barriers, there are of course other barriers as well to the realization of citizenship rights. Linguistic barriers, already mentioned, but also administrative, bureaucratic barriers, or lack of information or a lack of solidarity, for example, between citizens. These barriers we already identified in our description of work, and that is actually we presumed that those barriers actually exist, and now we are indeed looking into them and see whether they really do exist. Now we see also that different categories of citizens are being differently affected. So now I turn to the third part of this presentation, the scouts then having been sent away to look into these rights, but also to look at different groups of citizens. So here we focus on gender and generational aspects, as well as on the insiders and outsiders. And the researchers engaged in this research, this is in particular work package 9 and 10, have also come up with interesting findings in this respect. For example, women are vulnerable, and particularly the female migrant workers. We also found out that the differences in welfare systems and the difficulties in the portability of social security rights lead to barriers for both women as well as the young as the elderly. So suggestions have been put forward for the EU to focus. One of the suggestions or guidelines of the EU should focus on the citizens' rights as citizens as care workers and those as care recipients. Why do I mention that? Because what the research findings indicated is that the EU focuses very much on the female worker as the sort of standard model. But there are other groups or categories of citizens that are more being affected, actually. And so this is one suggestion, not only on the female worker model, but maybe more specifically on certain types of work or work models that the Commission or the EU could focus on. Well, reflections on family law are needed. Of course, we know that the family laws of the various member states differ widely when it comes to, I mean, this is an area that is being researched on both by lawyers within the context of the civil rights that citizens have, as well as by social scientists. How does this affect certain categories of citizens? Does it indeed affect more women or more young people, for example? The researchers engaged in what we say then the research on insiders or citizens being regarded as insiders and outsiders see that European citizenship as a concept reinforces the worker-citizen model. Actually, that is also something that the research of the lawyers within the context of the civil rights see, that although we have this concept of citizenship developing and giving citizens far-reaching, relatively far-reaching rights, civil rights, it's still very much related to mobility as well as to work or being economically active in some way or the other, because otherwise at least EU rights are not being triggered. So, according to their research, it seems that European citizenship reinforces this worker-citizen model. We see, however, that the idea of insiders and outsiders, for example, EU citizens are always insiders and third country nationals are always outsiders, or workers are always insiders and non-workers are always outsiders, that this has to be nuanced, it has to be put into perspective. And for example, nationals are always regarded as being the insiders. But if we look at certain groups of citizens, take the Roma as an example, who might be nationals of a member state, that they face more barriers than maybe EU citizens coming from another member state, or third country nationals even. So we have to put that into perspective. There's a kind of differential inclusion. Now, what we also see that some movers within the EU, those who are engaged in this type of research and analyzing data, they see that some movers are always visualized or visibilized in data. And for example, when it comes to asylum and asylum seekers, which of course is a good thing in itself, but maybe other movers should also get similar attention. Migrants and vulnerable citizens, for example. So it depends also, these barriers, as to what kind of category of citizen we are talking about. Now then, we are looking into the future as well, like Harry Potter has been doing a lot when he was at his school. And we probably don't have the same ambitions as Harry Potter or the Hogwarts, what is at school for Hocus Pocus, but we really try to base our future sort of idea and conceptualization of citizenship on our research findings. So we are seeking to develop certain scenarios. We call them what-if scenarios for citizenship 2030. So what, for example, if the economic situation or economic crisis of the EU is very persistent? What will then happen to this idea, this reality of citizenship? So based on a number of questions to develop future scenarios, citizenship, and how then could these scenarios help the EU to overcome once again these barriers? And then, of course, we are engaged in a kind of impact assessment analysis as well. I mean, that is something that is now sort of starting, because we have first, of course, been engaged in our groundwork research, and now we have to bring this later on a step further and to analyze the consequences of our research. One of the very specific outcomes of our research should, the outcome of our research should result in a very specific kind of tools designed for schools, kind of education material on citizenship. And that is not, of course, necessarily sort of educating citizens as being the good EU citizen, the homogeneous EU citizen, which once again we depart from a different kind of idea, but how could already in schools pupils get familiar with narratives on citizenship. Because I know that in the Netherlands, I don't know how it is in Italy, but when my two sons were at primary school, they had, I think, one lecture and one test on the EU institutions. And my son said to me, well, it is the European Commission that decides everything. And I should say, of course, no, that's not true. But in my mind, I thought, yes, of course, because they are the most powerful still, in my view. It's very powerful, but that was not really the correct answer. But so there was, I remember that once, but that was only once when he was at primary school. Now, in the end, then the scouts, of course, which have been sent away to examine these various pathways to citizenship, to look into these rights and the barriers to the exercise of rights, to look into these different categories of citizens and what kind of implications that has for citizenship. They come together again in order to, well, sort of come up with a synthesis or some form of synthesis. And once again, that doesn't mean that, for example, we all have to agree on one concept of citizenship. No, it might be so that we come up with different narratives of citizenships, that the historians, from their perspective, have an idea about citizenship, pre-modern citizenship, which is more locally, regionally organized. But maybe we could imagine that when it comes to social rights, we need a more common approach at some point of time. Perhaps we need that. Doesn't mean that you have to have a same conception of social rights, which is in contrast or in violation with the principle of subsidiarity. After all, as it is being exercised, well, that is a principle you can go all kinds of ways with. But we could imagine perhaps that that is happening, that we have different kind of narratives on citizenship coming out of our project. What we will do is how we will bring it together is that we look at these rivalries at different levels. And so we look at the local, national and EU level, and we compare these local, national and EU levels with each other, and what can we learn, especially from the local and EU level. We have already seen that the Swiss and Canadian models might be interesting there. We look at this rivalry of categories of citizens, so implications for insiders, outsiders, gender, generations, and what is actually an insider and outsider. We look at these rights, they rival with each other. And then, of course, we have a conceptual approach that we will eventually come up with on citizenship. And could we say, for example, and then I really would like to conclude with this, that indeed, so far, that is what we have concluded in our civil rights work package. It's still fragmented, it's derivative, it's a very thin concept, European citizenship. It's still very conditional, it's sometimes exclusive, and it's liberal. Well, this is a lot of adjectives, so but maybe food for thought. Thank you very much.
Thank you very much, Professor de Vries, for this very interesting overview of the topic and of the part of our first result of the bEUcitizen project. So just a few words, because time is running. I was thinking that first, then I myself presented bEUcitizen program in the school, to high school students, and I was really, I realized that the students have a sort of instinctive idea of the right of being a European citizen, and that I wrote a blog for our website, and that was really, really interesting, a very interesting experience. And, well, I think that all this program is all stimulating for us. I'm looking to Professor Tognati, who is our former dean. Is leading research program on pluralism, so on cultural aspects, linguistic and citizenship. So I don't know whether all this might be interesting for our project too. Okay, I would suggest to postpone the debate at the end of the round table, if you agree. And so I would ask to Flavio, Guella, Paolo, Guarda, and Teresa, Solis, Santos to take the floor. Thank you very much.
In the room?
Yeah, maybe.
Should I sit there? Yeah, I should be more comfortable.
Can you just stay there?
Ok, sì, sì.
10 minuti?
Sì, sì, sì. Inizio. Okay, thank you very much, Elena. And to start, as an example of the relation between factual and legal barriers, I was thinking mainly, first of all, to the topic of the European public financial equalization rules. As a title, I can anticipate, I will speak about the factual differences in the member states' revenues, financial resources, as a barrier to the European Union citizens' rights. And my purpose, very briefly, is to briefly describe the general problem of redistribution in federal systems as a problem of reconciliation of factual financial differentiation on the one hand, to realize autonomy, and citizens' legal equality in taxation and social services on the other hand, to realize, on the contrary, equality and an equal national system of public expenditure. Therefore, I want to have a look to the present approach of the European Union to this same equilibrium, by means of the cohesion funds, mainly, and the tax harmonization, and to the present approach of the Italian regionalism to the same topic, to check the comparability of those two systems. And at the end, on such comparative basis, I want to propose just a preliminary reflection on the structural limits of EU redistributive policy. In particular, the question is if the European Union regulation in the field of redistribution can be improved using the present legal basis in the treaties, or if we have a structural difference in the EU and in the national citizenships for what concerns the fiscal matters, with EU citizenship that is a status made mainly of rights and not of duties. That implies an underestimation of the solidarity values in tax regulation of the factual asymmetries among the member states. First of all, it is typical of federalism that the citizens are legally subject to different territorial taxations and benefit, on the other side, of a factual different level of public expenditures. and these depend on national, regional, municipal decisions, and therefore an high level of differentiation is possible in the federal systems as a constitutional coherent result of the frame of government. Anyway, also the Bill of Rights is involved in such a territorial organization of the public powers, and the federal citizenship is indeed not differentiated, and as a consequence of this not differentiation, it exists a common standard of protection of citizens, federal citizens' rights, even in a plural frame of government. Therefore, from a public finance point of view, on the one hand, a constitutional recognition of the territorial autonomies and their factual differences permits to discriminate in taxation and in the expenditure levels. On the other hand, a single federal citizenship imposes a certain degree of solidarity in the legal harmonization of taxes and a certain level of uniformity in public expenditure, using an equalization system implemented for social cohesion purposes. And such a corrective approach is evident in the cooperative federalism, for example, in the Grundgesetz that use the clause of equal standard of life, also in the fiscal federalism perspective at Article 106, and the Canadian cooperative federalism since the rental agreement in 1947 gave a great relevance to the equalization. And anyway, the same relevance of citizens' right equality limits the financial differentiation also in the dualistic federalism, like in the United States, for example, where after the 16th Amendment, the Federation had much more resources to use and developed federal programs by means of federal grants, like Medicare and so on, or in Switzerland also, where even if the confederative origins of the state brought to a competitive fiscal federalism, nevertheless, the Article 135 imposed a system of equalization directed to guarantee a reduction of the factual differences among the cantons. Therefore, all the experiences of fiscal federalism logically imply different de facto distribution of resources and different legal frames of taxation and public expenditures, but also a limitation of such differentiations to protect the equality of citizens, the equality of citizens' rights. On the one hand, the autonomy of member states implies financial differentiation and competition among the territories, and competition made the local public administration responsible for their tax pressure and for the level of expenditure and services. On the other hand, a single citizenship as a single status impose a certain level of non-discrimination of all persons in the tax burden on the one hand, and in the access of services implied by the public expenditure. And such second perspective requires an institutionalized solidarity among member states and territories. Against this background, the question is if the European Union law has something to say on those two perspectives, competition and solidarity in the fiscal systems. And in other words, the question is if the European Union citizenship can be a limit in the financial differentiation of the European territories, introducing some principles relevant for redistributive purposes, equalization and fiscal harmonization on a legal point of view. In the European Union, indeed, a fiscal harmonization was already implemented on the basis of Article 110 and following of the Treaty of the Functioning in the numeration nowadays, for indirect taxes, and in interpretative way also for direct taxation. But the level of harmonization is not strict, and the ECJ expressly admitted in many cases a reasonable possibility of fiscal differentiation on national and on territorial basis, also in a very high degree. And in addition, it was developed a European Union regional cohesion policy with the aim to promote cohesion among the territories of the single market, and it is to be verified if such a redistribution can be relevant in a civic protection of rights perspective. Indeed, as the treaties introduced a logic of EU citizenship, the approach to territorial differentiation in taxation and in the financial capacity tends to assume relevance also in the individual rights perspective, but the problem is which level of equalization the European Union law needs and which model of equalization can be implemented on the basis of the treaties, on the nowadays positive law. And on this point, the European Union cohesion policy is structured for a redistribution of resources coherent with the European Union objectives, and the quality of citizens' rights is not the first reason of the cohesion funds nowadays, but on the contrary, the first aim of the cohesion funds mechanism is the implementation of the EU policy. Article 174 and following the Treaty of the Functioning define the procedural frame of the founding mechanism, but in a substantial perspective it is to be underlined that the programs are not directly to a general equalization of the fiscal capacity of the European territories, but on the contrary, to the financing of single interventions that have to be coherent with the Lisbon Agenda and the Horizon 2020 perspective. Therefore, the aim of the cohesion funds is to implement EU development policies on a regional basis and not to directly equalize the social rights standards relevant for citizens. And on the contrary, equality of citizens approach using equalization funding is more used in the regional and federal system, and indeed at national level a single programs approach to redistribute resources is less common. And the first approach, the equalization, general equalization one, was experienced by the Italian evolution of equalization funds in the regional finance reform in the 70s, in the 19th, and in 2009-2011 reforms, while the second model, and it is a general model in the Italian experience, while the second model was tested as inefficient by the Italian evolution of special funds like Cassa del Mezzogiorno for the south of Italy development, the approach to single programs of development instead of equalization grants. And the Italian history is therefore particularly interesting for the mistakes in the equalization policies occurred during the implementation of Article 119 of the Constitution, both with a special development funding approach, so as in the general equalization approach. And a long description of the Italian law could be done, but I will not. And simply against this background, this comparative background, it is relevant that balancing solidarity and competition appear the main reason of the Italian fiscal regionalism reforms. And the same balance, solidarity, competition among territories, is relevant also for the European Union cohesion policy. And the EU, nevertheless, has a different structure. It's not regional, it's not federal. And as a consequence, it applies, the European Union applies a prevalent logic of indirect and not direct redistribution equalization. Still now financing specific programs useful both for the EU agenda and the territory development, not only for the territory development, and indirectly, only indirectly, useful for the citizens' equality in the social rights. The cohesion policy funding, however, is concentrated on less developed European countries and regions in order to help them to reduce the territorial factual disparities, and for this purpose the co-funding is between 50 and 85%, depending on the level of the gross domestic product. And in such profile, the European Union mechanism acts indirectly as a citizen condition of life equalization mechanism oriented to the solidarity and to reduce the barrier, social barriers connected to different degrees of development. Okay. Nevertheless, territories are in competition to obtain the funds because only the better projects are co-funded by the European Union, and in such profile, EU cohesion policy is not an equally tool but a territorial development tool directed to promote responsibility and competition, avoiding the weakness of the Italian model of special funding, like Cassa del Mezzogiorno. This second competitive project logic, different by the Italian experience, seems prevalent in the European Union regional funds perspective, and it lacks an equalization logic that can be measured on the basis of the level of social rights convergence. And also the 2014-2020 agenda confirmed this approach. The use of regional funds is linked to the economic reform of the Commission agenda, and the Commission could suspend funding directed to member states which does not comply with European Union economic rules. And the funding is made on the basis of 11 thematic objectives which main purpose is to promote growth in the territories, to have a convergence in the interest of the member states equalization, not individual citizens' rights equalization. Okay. And as a general consequence of this approach, not individual rights approach, but political, territorial, general development approach, some consideration can be made in a couple of minutes. The question is if a higher level of solidarity inside the European Union fiscal citizenship is possible, acting only on the side of public expenditure, introducing some constraints on to the level of factual differentiation on territorial basis. And evidently such upgrade of the logic of the European Union cohesion policy is not allowed without a parallel change in the legal tax harmonization logic. In other words, surely the European Union equalization mechanism is incomplete in a federal or regional state perspective if compared with a different frame of government, like it is a national frame of government one, that focus directly on the equality of citizens. The task of the federal state is also to focus on the equality of citizens. But the incompleteness of the European Union approach is imposed by an insufficient level of tax harmonization that the European Union cannot impose with the treaties nowadays. Therefore, the proposal of a stronger financial union in Europe appears a perspective that could change also the consideration of citizens in the functioning of the cohesion general mechanisms, but this one is a hypothetical future reform perspective and not the description of the fiscal citizenship in Europe nowadays that mainly remains national or, in some extent, territorial. The fiscal citizenship is national in Europe and sometimes territorial. Special region has a different fiscal citizenship. This topic is nevertheless surely very sensitive because it involves an essential sovereignty profile, the taxation, but nevertheless such a topic appears essential also in the European Union citizenship perspective and not only in the national one. Indeed, citizenship as a status, from a legal point of view, also the European Union citizenship is a status, is a compound of rights, but it is also a compound of duties. And the sentence, no taxation without representation, underlines how the two status, the two figure of citizens and taxpayers are strictly linked and are central in the construction, in the development of the modern state. And to conclude, to empower the European Union citizenship, in this perspective, it could be important to say something also about the duties of citizens in the field of taxation, both in a redistributive solidarity perspective, the duties of citizens on the solidarity field, so as on the ground of the more general taxation principles that contribute to define the figure of the single person, not only like a citizen, but also like a taxpayer, and the two status are usually not divisible. Thank you very much.
Thank you very much, Flavio, for this very interesting approach to European citizenship from the point of view of fiscal harmonization. And I give the floor to Paolo.
Good afternoon to everybody. I'm proposing a particular point of view to the issue of barriers and citizens, even a not so usual one for IP scholars in a way, because usually IP scholars don't start from this point of view, but starting from other paths. But I guess it's a quite interesting one anyway, since we will register the coexistence of legal and factual barriers together. It also stressed the importance of this kind of barriers even by the digital single market strategy approved last year, that actually were stressing the existence of these barriers within the copyright system in Europe. And so it's, again, pivotal and central to our bEUcitizen research. I have 10-15 minutes, and then I'm not going into details. I will try to get you at least a flavor of the complexity and pinpointing the main barriers involved. In this, creativity and innovation within EU actually are part of a harmonized system of protection. So in a way, we will see in 1 minute several directives dealing with harmonization of copyright, IP and on copyright. Internet and digital technologies play a pivotal role in this context, since they transform and they are transforming the world we live. And we will see that it's affecting even the scenario on which we apply and enforce copyright regulation, IP regulation in general, actually initially framed on a different technological context. And then we have new digital opportunities, new business models. We register several barriers to online activities, and these barriers actually prevent citizens from taking advantage of the wider range of goods and services they could get online, but even public administration, even private companies. And actually, digital single market, where we will see it in a while, is aimed at breaking down regulatory barriers, even in the field of IP and copyright. As you maybe know, IP, intellectual property rights, involve several tools, with several regulations, different kind of sometimes rationals. So we have patent for new inventions, copyright. So in order to be efficient in this kind of research, we need to narrow our field of research and then to focus on copyright. Digital single market helped us in that way, since it is profiled on copyright issues. My agenda, a very brief agenda, is to provide at least the legal frame of EU copyright legislation, 30 seconds. And then give you some hints, some of intersection among copyright and fundamental rights, and dealing with digital single market, pinpointing legal and factual barriers, and then close it. So actually, within the EU, we have a set of directives, only focusing on copyright. I guess I meant 10 directives, I'm not wrong, starting from 1991 with the Computer Software Directive, Computer Program Directive. The legitimation of this kind of intervention by the EU was due by the now Article 114 of the Treaty on European Union, that actually enables EU legislators to enact measures designed to pursue the approximation of laws for the creation of a single market. So thanks to this kind of enabling provision, EU took the chance to provide directives on this field. Now, after the Lisbon Treaty, we have Article 118 that actually provide the possibility shall establish measures for the creation of European intellectual property rights to provide uniform protection of intellectual property rights. So even the possibility to act through a regulation in order to uniform and unify the system. And that's on the table now with respect to copyright, and it's also the process that we are registering with respect to the unitary patent. So we have several kind of directives. We are not going into details on that. We may register even a sort of, not clash, a race between European Commission and the ECJ, the European Union Court of Justice, in interpreting and try to updating the regulatory framework. And in this respect, actually, the Court of Justice is playing a pivotal role, a very important one, providing a sort of unintended harmonization of the European copyright regulation. The European Commission now, thanks to the digital single market, are trying to get its role. Some scholars say that the EC could do much more with respect to that, but that's also an interesting issue. I have to run on this respect. Copyright is also interesting since we have a lot of overlapping and clashing with other rights. Copyright versus privacy, pro musica case, or when an ISP service provider wanted to get, right holders want to have by the ISP the name of people who are maybe infringing copyright of somebody else. We have clashes among copyright and freedom of information or freedom of economic initiative. Svensson, Scarlett are quite famous cases with respect to linking, with respect to the taking down of content by content providers, or copyrights versus freedom of movement. And we will see also this is a pivotal issue and a factual barrier, even when we are dealing with geo-blocking or technological protection measures that actually avoid the possibility to move within EU and get access to the services. Just a few words with respect to why we need a modernization of the copyright. This is Gutenberg. So copyright dates back to 15th century, so to the movable typing technology. Before Gutenberg, we had no copyright. After Gutenberg, we introduced copyright. Since thanks to a new technology, we had the chance to provide for copies in a lower price, with a lower price. Before Gutenberg, the cost of the copy was the same of the original. We had to pay or to get a slave in order to copy the book. Now you invest money in order to have the matrix, and then the cost of the copy are lower. And then you have to regulate the market, the first publisher, the first stationer, and the second one. And then we provide for a second best solution, an exclusive right, a monopoly on a person, the stationer, but actually balancing this power with other kind of exception and limitations. The digital, and actually copyright was framed around that kind of technology, so paper technology and book. And that explains also why we have all these problems now to enforce this kind of regulation to a complete digital, complete change digital scenario. Digital revolution actually affects the possibility to make copy, the cost of the copy, the quality of the copy that's the same of the original, but also the distribution, the possibility of distribution. So we don't need intermediaries now. You just keep your copy, you put in a peer-to-peer system, and you distribute your copy to billions of persons. And these possibilities actually crack down the copyright system in a way, creating even new processes of creation, new processes of sharing, new processes of distribution of the copyright-protected work. In this respect, we have the digital single market, approved in May the 6th, 2015, in order, from our perspective, to ensure that consumers who buy or subscribe films, sports, e-books, can access them when they travel in other countries. And so in order to create a single market, even in the digital context. And actually, we have three main pillars. The first one is pivotal for us, better access to online products and services, and it means unlocking e-commerce potential, simplifying value-added tax arrangements, modernizing copyright, and we'll focus on that. The creation of the right environment for digital networks and services to flourish, and it has to do with the rolling out fast broadband for all, but also to a strong European data protection rules in order to boost the digital economy. And we know that finally we had some days ago the publication of the General Data Protection Regulation that will be coming into force in 2 years. And then the promotion of the European digital economy growth. Several actions are needed, of course. Reform of the rules for cross-border online sales, stopping the so-called geo-blocks, we will see it in a few seconds. The EC has already presented its action plan in order to make EU copyright more feasible to the digital age, and a regulation to enabling the cross-border portability of digital content. The main issue is, maybe the famous one is, I'm subscribing a service here in Italy, and if I'm moving to the Netherlands, I'm not able to get the same service because I moved to another country, or I cannot have access to a service provided in Germany and the Netherlands because I'm starting from a node within Italy. And I mean, the strategy by the right holders is clear. In this way, they can partition the market and then carry on a price discrimination activity. But I mean, it's a typical barrier to the movement of services and persons. Okay. Already said that. The current regime, the current legal regime actually presents no advantages for anybody. Any of the parties, every party involved is complaining from different positions. Large companies are complaining that they are not able to stop the circulation of pirate or illegal copyright work. Emerging professional creators are complaining because they cannot enjoy a profile, legal content, legal tools in order to enforce their rights and their activities. Consumers, users are complaining since they cannot enjoy new business model really profile to the needs they have. So everybody is complaining about that. From the point of view of the society, of the users, there is also a lack of public legitimacy of the copyright. So people is starting to say why we have all these kind of regulations actually are affecting us to get access to content, and content that we may use to run. And also lack of flexibility in a way. I skip it. So just few slides with respect to the legal and factual barriers. I also got as a reference this resolution of the EU Parliament. It actually adopted the non-legislative report of Giulia Reda. It's quite famous when you are working on this kind of issue. And then we have legal barriers and even factual barriers, technical barriers. In that respect, actually, the regulation is not needed to harmonize the system, but even to neutralize with positive actions these kind of barriers carry on implemented by the right order. So the first barrier is the exceptions and limitations. So fair use, fair dealing, freedom of panorama, possibility for libraries to lend works in digital formats. These are lung of the system. So this is the flexibility of the copyright system. So the state is granting a monopoly to the author, or the right holder, but it's balancing this monopoly right with some limitations, and they are pivotal. And InfoSoc directive was intended to harmonize this kind of exception limitation, but in a way it failed, since there was too much freedom for member states in order to implement in different ways the limitation exceptions. We are starting dealing with the possibility to have a single EU copyright system. Instead, copyright IP in general are affected by a territoriality point of view. If we take into account US and EU, we have that in the US we have a federal regulation legislation, then every company in the US are using the same title. In the EU, we have an harmonized context, but then every company in every country is using a different title of copyright, even if harmonized. So, and that could be a title carrying on implemented by a regulation. We have the problem of licenses, proprietary licenses, open source licenses, and also the intersection of all these kind of licenses in a way are creating transaction costs for users in order to be able to understand which are the rights delivered or granted when they are accessing to content. I'm sorry, I'm really running, and I'm coming in 2 minutes. Job locking, I've already told you. That's quite a paradox in Europe, where the citizen can move freely and without restriction, or could maybe. Actually, digital context not, and then I cannot access to the same services moving around, but then we have a regulation that even somebody is complaining that it's not enough, but it's trying to bridge this gap. Digital right management, I run. We have problem with infringement. It's quite funny, this kind of, reading this text constitutes copyright infringement. You are under arrest. So there is a lack of efficient tools, and now the European Commission is working on the follow the money tool or the notice and takedown tool. But then, by the other side, even it's important to understand what is really illegal now. If so many people are carrying on an activity that actually is not perceived as an illegal one. Internet access, but actually this kind of psychological pressure that is really linked to what I'm talking about with respect to infringement. This was a commercial quite famous some years ago. Before watching a movie in the movie theater, you had to got this kind of commercial in order to make us perceiving the downloading of a music as the same behavior of stealing the bag of an old woman. And so you have to feel a bad guy when you are downloading, when my cousin is downloading a lot of movies. He's a bad guy. This kind of pressure, it's also pressure by right holders, is also a way to try to affect the context. So, final remarks. In this kind of field, we have the intersection between legal barriers and factual barriers. That technological changes actually affect even the content. So we always have to check the IP tools with respect to the rationale they should address. And they are not addressing anymore that rationale that actually the fostering the creativity process. Maybe they are not working anymore. We have new processes based on sharing, and then I need to modernize and update copyright. These are you exhausted by my speaking. I'm paranoid of aphorisms. I usually finish all my lectures with this aphorism by Seneca that has to do with ideas. It's not related to copyright. The best ideas are common property. That's my approach to the issue. Information ideas should be free by nature, and then we should impose limitation, exclusive right, or monopoly only when they are really needed in order to foster creativity in a particular technological scenario. So the default rule is freedom, and we have always to check limitation with respect to the rationale. I thank you, and this is my contacts.
Thank you very much, Paolo. And now, Teresa, please.
Thank you, Elena, for having invited me to this seminar and for having given me the chance to be here this afternoon. The barrier or the hydrants I would like to present to you during this seminar has its roots in the legal regulation, and also it has been objected to several or considerably interpretations by the national courts. The barrier that I'm talking about is the consideration of sufficient resources for not to become a burden for on the social assistance system of the host member state. This barrier has a special consideration or importance for EU citizens when willing to establish in Belgium. So I'm going to give my ideas or this speech from the point of view of Belgium as a country and how Belgium is acting to this. Well, what is sufficient resources or not, it has been settled down in the so-called European Citizenship Directive in Article 8.4. The directive or the article indicates that the member states may not lay down a fixed amount which they regard as a sufficient resource, and they must take into account the personal situations of the persons concerned. Having this in mind, or this article has its reflection in the Belgian national law in Article 40 and 42 of the law of 15 December of 1980 on access to the territory, residence, establishment and removal of aliens. This Article 48 settles the prerequisites for a citizen to be fulfilled when willing to reside in Belgium for more than 3 months. and within the bunch of perquisites settled down, one is the sufficient incomes. This article in the last paragraph tried to give a reference or what is considered a sufficient income for Belgium. And it says that at least to have the level of income at which the person can receive social assistance. In the following line, it's also indicated that it has to be considered the personal situation of or the personal circumstances of the persons. Well, how is Belgium interpreting this? Because this is the theory, it's in line with the European law. I'm not saying that Belgium is not acting well, but maybe it's having a very restrictive opinion or application of this. Well, as I have indicated, one of the main barriers for EU citizens and for the family reunification of EU citizens in Belgium is to fulfill this kind of perquisite. The Belgian Litigation Alliance Council, which is the tribunal responsible to study this kind of cases, as well as the legislative powers and the political powers, has a tendency to subordinate the right to residence to protect Belgian public finances. And so the main discussion or dispute is to determine what is considered or not as sufficient income or resource. Well, to not have a sufficient income or to not show that the citizen has a sufficient income for himself or his family has led the expulsion between brackets from European citizens of Belgium. In the last 2 years, 2013, 2014, 2,700 European citizens has been expelled, or also we can use, they have been administrative death in Belgium. This means that they have, with Belgian authorities, has withdrawn the resident permit of European citizens in Belgium. It's not a expulsion, but it's a kind of, well, after the amendment of the law of 1980 in 2011, the conditions for European citizens to settle down in Belgium have become stricter. This situation has an explanation in the politics itself. This means to form the government of the RUPO in 2011, the political parties of Belgium, they have to get to an agreement. A part of the agreement was to merge in the same person or in the same department the Alliance Office, the Office of Foreigners, with the social assistance. So this means that an automatic change of data between these two authorities, which they became in the same department. And also another novelty was that it has been settled down a minimum amount for the family reunion, to allow the family reunion in Belgium. Consequently, the prerequisite to not become considered as a burden for the social system of Belgium is to have an income of 120% of the minimum revenues of social integration. This is also indicated in a law. So this means a minimum amount around 1,300 euros, more or less. This amount is taken also in special considerations when examining the family reunification and the situation of the reunified. Under the eyes of the Belgian national authorities, EU citizens will become or will be considered a burden of the welfare system of Belgium when a low pension is compensated with a CPA help. CPA help or OCMW, depending on where you are, in Wallonia or in Flanders, they are they are centers of social actions, and what they do is they deliver a number of services, and they try to ensure a well-being for every citizen. Under these kind of services that they deliver, they not only deliver, or they don't only grant to citizens monetary help, they also grant help, for example, in case or support in case of an emergency, in a medical emergency, also pharmaceutical, also if they need legal help, also if they need help in, they do some mediation and arbitration. So it's not only economically. Well, this doesn't mean that a European citizen cannot ask for this kind of help. However, and this doesn't mean that this kind of social action servicer or provider will not grant to the European citizen this help if they need it. But on the other hand, what they are doing, or what they have to do, is they inform to the citizens that in case that they ask for this kind of help, their resident permit could be withdrawn. Because after 3 months of receiving this kind of help on a row, they will inform the Alliance Office, the department responsible for foreigners. And then they will start a procedure to really seek if you are a burden or not, or you can potentially become a burden for the social assistance system in Belgium. How is interpreting the courts in Belgium this? They are excluding a lot of incomes from the revenues of a family. And they're excluding also incomes like, for example, emergencies, CPA's emergencies help in case of a medical emergency or just pharmaceutical. Because of this, they consider that the person does not fulfill this minimum amount of 1,300 euros. The temporary revenues, they are not taken into consideration when examining the situation of the family. What has happened with this? Well, the reaction to this kind of behavior has resulted in a petition in front of the European Court, a petition presented to the European Parliament by a group or an organization of the 15M Brussels Marea Granate, because one of the biggest groups that has suffered this kind of expulsions from Belgium were Spanish. And still the answer is still pending. So I really don't know what is going, if it's going to really consider that if Belgium is really hampering the freedom of movement and reside within the European Union or not. And thank you very much.
Thank you, Teresa, also for being perfectly on time. Before the coffee break, is there any question? Yeah.
Yeah, I have a number of questions, but I will also leave some for later. Thank you very much for your all the three presentations. So they were very interesting, very different, and very often also thought-provoking. And one short question for Teresa. For the last, I was wondering, because I thought you wanted to mention or
Yeah, I have made a general conclusions of how the courts are ruling, not only in the family reunification of European citizens, also of third country nationals with European citizens, and they are excluding from the concept of having sufficient incomes some revenues. For example, because they also need the revenues, they not only need to be sufficient, they have to be on a regular basis. So they have to be regular and stable, not only, and this is the interpretation that Belgium is doing.
The court excluding certain revenues from this, okay.
Yeah, so in different cases, in different cases, they are excluding. For example, there is a case in where it has been the Council of the State has considered that the interpretation of Article 43 of the law of 15 December 1980 was correct, and they have excluded from considered sufficient revenues the guarantee revenue of an elderly, and they have considered that this revenue falls into the complementary resources. They have not considered that it falls on the. This is an example. Another example that I have here is that the CPA help, not as an income itself, only in case of a health emergency or pharmaceutical emergency of a person who was subscribed to this service, cannot be considered as having sufficient incomes. And just because it was receiving these CPAs, it goes already under the minimum 120% level of the minimum integration revenues that they need to have. So just by being attached to this system. So, and this a problem, I'm not saying that Belgium is not in line, I repeat it, but maybe the interpretation is quite restrictive. Absolutely. Because yeah. it's not that probably not, in fact, it's not, because they are not only examining if it in fact is a burden, but they are also examining if it's potentially a burden. Yeah. So it's, for me, this is the main problem, to be considered potentially a burden if I'm not yet. Yeah, exactly.
No, it is really interesting. I think it's very interesting also. So maybe Martin has a, yeah?
Thank you very much. I just have one question. Does it apply irrespective of the duration of residence? How do they deal with that issue? Because there are a number of issues associated with that, right?
Yeah, in theory, should not be considered, because when you receive the permanent resident, the theory says that they don't have to check these kind of facts anymore. And I'm not only. Now I'm extending also to the right of residence itself, permanently. But the fact is that when the citizen needs to, because of a low revenues that they have, imagine you have been working, but you have not enough, work enough to get unemployment fees. In Belgium, you can go through these CPAs to get some equivalent. The fact that you ask to this CPA for any help, or this is so far my investigation, still has to be investigated more in depth, because it's something I'm really interested in also. The fact that you ask for this CPA's help or Ocean Well help will already put an alarm to the Office of Foreigners, like, look, this person is maybe trying to abuse or trying to use our incomes, our social help.
I think that's really interesting, but that is kind of the last example is a worker, and that's the question of what constitutes a worker.
No, in fact, for the worker
there shouldn't be anything, right?
For the worker should not be anything, but I know a case, a close case, in where it's a mixed marriage between a national Belgium with a third country national. And he was working, but he could not get this minimum amount. She was working also, and she could not get the family reunification itself. She could not get the family reunification because he was working. So really the situation of the family or the other things, I really don't know how they are really examining everything.
And how do they assess if I've been resident in Belgium for 5 years as an EU citizen, EU migrant citizen, legal resident for 5 years or longer? Would they still apply that without having taken up permanent residence? Because that's, you know, a question of how does that work. So it's a question of EU law, 5 years of residence, I should not be discriminated against. And between 3 months and 5 years, you know, the Dutch have a real good system, you know, every day counts, you know, it gets a bit, they get a bit more lenient, and other countries have real problems with it. And so the question is...
Well, if you are a worker, you are...
Not a worker. So let's say I'm a pensioner. I've been stayed there for 5 years as a legal pensioner, you know, legal residence.
Then I don't know yet. So I have not examining, so I don't know. Okay. I will examine this also.
Thank you. 2 short questions as well to Paolo and to Flavio. Maybe start with Paolo, because you suggest that that the EU should strive for one copyright system. At least that is the outcome of the research that has been carried out by you and your team. That is eventually the only way forward, or are there any alternatives? Because I can understand that also in the member states there is still, or between the member states there's still disagreement on that issue as well. I mean, and furthermore, within the member state, there are discussions on exactly what you mentioned, that should we still uphold a quite old-fashioned idea of copyright protection or not, or is so these discussions also are going on within the member states. So how would you, sort of looking into the future, would you see that?
Actually, I've not real a solution, since the dichotomy among directive and regulation is still on the table. And thanks to I said that now we have Article 118, and European legislator has not taken the chance to use it yet. So it would be a way to enact a regulation and then a unified title. There are some scholars proposing this solution. For sure, from a competition point of view, would be a good choice, since we would have a single title applied to the entire European Union as for the patent, the same kind of process. Of course, with respect to the US competition and to US companies, and that's an issue. Then you have a lot of problems with respect to this solution, since, of course, it's an harmonized system that will copyright one, but then you have a case law quite different in every state, so originality has different meanings, and every kind of terminology has different meanings, harmonized but different. And then even the application, the enforcement of a regulation could have problem in the operational rules from this perspective. So actually, I cannot say that I'm completely sure that it's the real solution in a way. What is really important is to rethink about the framework and to rethink about keeping into account the rationales, so to address, and then to modernize the approach, even maybe providing for exceptions and limitations profile to the different context we are taking into account. So the traditional one, then the digital one. So it's true, the regulation is also appealing as a solution. And also the single title, it's appealing from the Jure Contendo perspective, it's okay, one title. Then it's true, we would have some problems with that. Maybe the patent example would be a paradigmatic scenario where to text this kind of approach for copyright. Quite more, with respect to patent, we had the European Patent Convention, okay, not EU, but in a way we had a unified processing and granting system for patent, having still national patent system. We will see if the EU patent, unitary patent will work, and then we will see if it's working even for copyright. It's challenging in a way, it's on the table. I'm sorry if I'm not providing a solution. I'm
I
not
can
Mr. Wolf of Pulp Fiction. I'm not solving problems.
No, but I can imagine, for example, that with copyright you have a lot of cultural difference, compared to patents, for example, where maybe these arguments are a bit less relevant. But
that's true. That's true.
I think this is no. Thanks. It's an answer that I was. I mean, the regulation.
Yeah. But there's also the cognitive approach to this issue. So some people are thinking that maybe copyright is not needed anymore, or some other people say, okay, it's needed, but thanks to licenses, then we can restart the creative process. So I mean, it's challenging. Of course, it's different from the industrial property side. Yeah. Two different rationales and two different scenarios.
Thank you.
You're welcome.
Maybe, I don't know if there's still a very short question. I could also leave it for after the next panel, because I thought the presentation by Flavio about the tax using not only tax harmonization, but also the cohesion funds and regional funds, and to see how we could link that to citizenship was really interesting. I thought at the same time I was curious about the Italian example and why it actually didn't really work out, or why that is apparently not an approach, equalization through kind of tax harmonization of citizenship, that the EU should not follow apparently. Is that too far-fetched? That was a little bit, I was more curious about the background of that example, but I don't know if there's time for that, or that we can do that after the 1 minute, okay?
He needs the microphone.
Thanks. Just in 1 minute, I can say that the tradition of the Italian equalization grants and development grants is very long and very differentiated, but the main weakness in the Italian model was that we used the development programs without a competition, a real competition among programs. The Cassa del Mezzogiorno financed some project not on the basis of a co-founding approach, and therefore the local investors were not so responsibilized like in the European Union model. Nevertheless, the European Union cohesion funds model is not an equalization grants system, and therefore the main purpose is not the equality of citizens, the equality of expenditure for citizens, but is the development of territories. And only indirectly it implies an equal social rights or economic developments, economic rights background for the citizens. So the European Union model is something between the two tools used by the regional state in Italy, the special development funds on the one hand, not like in Italy because more competition is involved in the European model, and the equalization funds on the other that is something not coherent with the European non-federal state frame of government. Thanks.
Okay. Any other question? Okay, so we can have a 15 minutes break. Thank you very much.